tonight. The first one is a proposed amendment to our special district, the Southpointe Special District. It's an amendment to consider some land use category issues, or changing land use category issues. The second one is a conditional use hearing for a cellular tower along Han Road. Now, in that first hearing we're starting tonight, and we've had several hearings on this, and came to our attention at the last hearing, where we had a typo in the date. The day of the week wasn't correct, so we are reopening. We're starting this hearing again to correct that. There were some interested parties that came along, weren't aware of that date, and they're here tonight, so they have a right to be testimony put on record for that hearing. So we will be doing that one first. Then we will go immediately into the hearing on that tower application. So to start with, call this first hearing to order. Please can let the record show that Supervisors Cassiola, Fisher, Collins, and Gizio are in attendance. First one will be Carol Candy to swear in or anybody wishes to make testimony tonight. The first hearing. Candy.
Please raise your right hands. Each of you do solemnly swear the testimony you're about to give testifies to the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. I'm sure you're aware that it's an amendment being proposed, and I know you have an interest in it. I think you had some testimony to bring forth, so start right now.
Well, first I would ask, my name is Robert Blooming. I work at the Southpointe Golf Club.
We would ask that you go to the microphone so everybody
Okay.
can hear you. Thank you.
And if you please pick up the microphone, it does
It
help
works
if
if
you hold
you
it.
hold it.
Hello.
Okay.
That's great.
It works.
My name is Robert Blooming. I represent Southpointe Golf Club, the owner of a large tract of property, over 100 acres in South Point. I guess before I begin with my presentation, I have some questions because nobody put into the record the advertisements for tonight's public hearing. So I have some questions to ask Mr. Bosley about the advertisements because I believe they are defective.
We can't hear him in the back.
I'll yell as loud as I can. Or I would invite people to move to the front also and yell as loud as I can.
I was going to say that you've never had a problem talking loud before.
I'm getting older since the last time we had these issues.
You have to put the
And just
mic.
keep the mic.
Yeah. So I'm going to ask Mr. Bosley some questions about the advertisements.
I would refer that to Mr. Volz because he assisted in the advertisements. Chris, I know you have some questions on that. Would you address them, please?
Maybe you can just generally state what your concerns with the advertisement are. And
Well, the first advertisement was advertised on June 28, 2016. And it says that the purpose of the public hearing tonight is to consider repealing and reenacting an ordinance adopted by the board on May 2, 2016. However, as I read this proposed ordinance that's up for public hearing tonight, it is a verbatim, word for word identical to prior ordinance adopted on May 2, 2016. The advertisement mentions a repealing of that ordinance, but there's nothing in the new ordinance to talk about a repealing, and I'd like to know why. Why not, I should say. I think the advertisement's misleading.
I don't understand why you think it's misleading, I guess.
Because the advertisement uses the word to consider repealing, and there is no language in the ordinance up for discussion tonight about repealing the prior ordinance. Nothing.
Chris, from our experience, whenever we reenact another ordinance, that by Pennsylvania law, it actually, by statute, repeals an existing ordinance that it's supposed to replace. Am I correct on that?
Then I would also state that one of the later whereas clauses state that we voted to enact a proposed amendment at the May 2 meeting, and that there was, it's not in the ordinance, but there, as everybody knows, a subsequent procedural validity challenge. And then the second to last whereas clause states that the Board of Supervisors, if they wish to go forward with this amendment, wish to repeal and reenact alleged procedural defects.
So is it the board's intention tonight, if you choose to adopt this new ordinance, to repeal the prior ordinance?
No, we don't act on anything tonight.
Well, that tonight.
Okay, let me rephrase that. When you do act, is it the board's intention, if you should adopt this new ordinance, to repeal the prior ordinance?
I think that's under consideration by this board.
Okay. Do you know the section of the statute you're talking about? Because I've looked for something like that, and I'm bound to see about that.
All right, the point is, do you want to bring any testimony on?
I do, but I have objections here that I'm entitled to raise.
Okay, you raised it, we understand that.
I believe this notice is deficient for that reason.
Okay, we
Next reason I believe your notice is deficient is the advertisement from June 28th says that part of the proposed purpose of the new ordinance is to set forth procedures to change land use category in vacant lots or parcels by requiring consent of 51% of the adjacent landowners and approval from the township. However, the new ordinance, the proposed ordinance, also proposes to add procedures and requirements to change land use category on developed parcels by requiring 100% approval of the adjacent landowners and approval of the township, and that is not in the advertisement either, and I would ask why not.
Well, I think you're familiar with the ordinance, that there are two separate areas in the land use category change. There is a paragraph on undeveloped lots and developed lots.
Yes, I'm familiar with that, and that's why I'm asking the question. You advertised the portion about undeveloped lots, but you did not advertise the portion about developed lots.
Subsection 2 of the advertisement sets forth procedures and requirements to change the land use category, land uses for developed lots or parcels, only by permitting changes to more restrictive land use categories and more restrictive land uses.
But it doesn't mention the 100% requirement, as it does the 51%. I'm asking why the board chose to mention one and not the other.
Okay, your point is taken.
Is there an answer to that?
This was a summary of the ordinance. I believe it accurately describes what the ordinance and gives an overview of what the
So
ordinance.
should I surmise it was intentional not to put in the 100% requirement?
I mean, I think you're misreading the ordinance too. The 100% is to get around the general prohibition.
I'm not reading the ordinance, I'm reading the advertisement. Your advertisement, I got it from the front of the room tonight. I also got it from the newspaper.
We get your point, we disagree with that.
No, I'm just asking, so was it intentional not to put the 100% requirement for changing the use of developed land the way you put in the 51% advertisement? Should I assume that was intentional?
I wouldn't
You can assume what you want.
Okay,
but-
can someone answer it for me?
We just said that you can assume whatever you want.
No, but I'm giving you the opportunity for me not to assume, for you to answer the
We're
question.
giving you the opportunity to testify. We understand your point. We ask that you move on to the next point so that you don't hold up everybody else.
Oh,
Excuse me, but this is a very important hearing about my client's property rights, and we're going to do our presentation here, and I'm asking for an answer. If your response is the board will not answer my question, I'll accept that response.
It would be inaccurate to say 100% approval would be required to get 100%. If you read the ordinance, which you have seen, there's a general prohibition from getting to least restrictive to more restrictive. That could be waived. The supervisors could waive it.
With 100% approval as a petition, right?
So as you
it's
know,
not- that's why it's not in the advertisement.
As you know, the solicitor is charged with giving a general summary of what the ordinance requires. I feel that the ordinance meets that requirement.
The MPC, I think section 107 says it has to be described with specific nature, and I don't think it does. But if that's the answer, I understand that's your answer. Next point I want to make is on the reverse side of this paper that was up front there tonight. It says the public hearing was duly advertised on July 2 and July 4, 2016. Now, the advertisement that's there simply states that a public hearing is scheduled will be held on Monday following the public hearing scheduled for 6 p.m. to regarding amendments to section 913F. And that hearing would be for the conditional use approval of Crown Castle. There's nothing in this advertisement that discusses the proposed amendment to section 913F. And the MPC does require 2 publications for any public hearing of this matter.
If you look at the front page, you see the advertisement for this hearing was published on June 28th and July 4th.
Okay, so I'm going to take the one that was at the front of the room, and I'm going to give this to the court reporter as marked Exhibit P. I only have 1 copy, but it's what's up front there, since that is your response to it. Next, I'm going to show you, and again, I only have 1 copy because I only saw this tonight, what's marked as Exhibit O, which is an online print. The Cecil Township publications are notices of public hearings. And you'll see that the online search reveals one done for June 28th advertisement and July 2 advertisement for the Cecil Township Board of Supervisors. The advertisement reference for July 4 says it's for the Cecil Township Zoning Hearing Board. I believe this municipality has failed to meet the requirement for 2 advertisements. That's for a zoning hearing board proceeding. It is not for this proceeding. We'll be getting a hard copy of the July 4th newspaper tomorrow, now that we saw this, but I believe you have not done the second advertisement. I'm going to give that to the court reporter as Exhibit O.
Okay, noted.
Does anyone have any response to that point?
So you ready to get on with some testimonies?
I'm just waiting to see if anyone has a response to my question.